Good morning, everyone. I'm Bob Fay, and together with my partner Kathy Halliday, we are going to talk to you today about disability discrimination. So what we thought we would do, rather than just trying to give you a broad overview of disability discrimination law, is to actually drill down in at least a bit of detail into some key areas to try and give you some tips about being aware of particular areas of risk and how to manage them. We also had a bit of a scroll through reported cases from 2020 and 21, and we've picked out 5 case reports from Employment Appeal Tribunal and the Court of Appeal that we thought were interesting or informative in some way, and we're going to run through those as well. In terms of timing, I think we're aiming to try to keep the first section on top tips to about half an hour, then deal with the cases over maybe 15 minutes so that we allow plenty of time for the Q&A at the end if you have any questions. But as with all of these things, no doubt there'll need to be a bit of flexibility. I wanted to talk to you about minimizing the risks of discrimination arising claims. Now, you may remember that back before 2008, there was a disability-related class of claim, and that due to the Lewisham and Malcolm case in the Court of Appeal, that category of claim became very difficult for claimants to successfully pursue. So it was felt that there was a need to change the law to bring it into line with what was required by the relevant European directive. And so in the Equality Act of 2010, this new category of discrimination arising from a disability was created. And as it says there on the slide, this is defined in section 15 as a situation where A treats B unfavorably because of something arising in consequence of B's disability, and the unfavorable treatment can't be objectively justified. So the tribunals then started to get to grips with what this actually means. And you may remember in 2014, there was a case called Weera Singh, where the president of the AAT said that there's 2 distinct steps to the tests that tribunals have to apply in determining whether discrimination arising from disability has occurred. So the first question is whether the claimant's disability had the consequence or caused or resulted in something. And then the second question was, did the employer treat the claimant unfavorably because of that something? I've said first and second question that the EAT did make the point that it doesn't matter which order you ask those questions in. And then in the other case that I've put on the slide there, which I'm going to say is Primaz, possibly, the EAT summarized the proper approach to claims for discrimination arising from disability as follows. So it's a series of steps. The tribunal first must identify whether the claimant was treated unfavorably and by whom. It then has to determine what caused that treatment, focusing on the reason in the mind of the alleged discriminator. That might require an examination of conscious or unconscious thought processes of the person accused of discrimination, but keeping in mind the motive of the alleged discriminator in acting as he or she did. The tribunal must then determine whether the reason was something arising in consequence of the claimant's disability, which could describe a range of causal links. And that stage of the causation test involves an objective question. It does not depend on the thought processes of the alleged discriminator. So where that takes us is that you have, certainly compared to, for instance, direct discrimination claims, you have only a relatively loose causal connection required. I've mentioned the case of Robertson on the slide, and that I think shows the limits and shows that there does need to be this chain of a disability, an outcome or consequence of the disability, and less favorable treatment because of that consequence, the something in the definition. it is required. And the facts of Robertson aren't particularly relevant to the discussion, but the important thing about Robertson was that the employment tribunal was asked to determine whether one of three different medical conditions, or any of three different medical conditions, I should say, amounted to a disability. It held that one of them did, and it held that there were consequences of it held that one of them did, and it held that the employee was treated less favorably because of some sickness absence, and then held that therefore there was discrimination arising. And the EAT pointed out that what it hadn't done was establish the causal connection between the disability, the sickness absence, which was the something arising in this situation, and the less favorable treatment. So it had to remit the case back and uphold the appeal because the causal connection hadn't been established. So it's needed, but it's relatively easy compared to other claims for a claimant to show that there has been a something arising from their disability. I mean, if you think about the definition of disability, it includes an impairment which has a substantial adverse impact on ability to carry out day-to-day activities. So if you have a substantial adverse impact, that's your something arising from your disability in most cases. So it's relatively easy to establish that. And then, based on the facts, they either will or won't be able to show less favorable treatment because of the thing arising from their disability. But for practical risk management purposes, what we tend to see is that the battleground in discrimination arising cases, because of that relatively loose need for the causal connection, tends to be the issue of objective justification. And what that means for HR practitioners is that it becomes very important to be aware of the need to consider the objective justification ingredients when making key decisions. Now, sometimes that's a very straightforward and obvious thing when you're making a key decision. The most obvious example being an employee who's off sick for a long period and may have an underlying health condition, and you're making specific decisions about what to do about it. Sometimes it can be less obvious, and you can be faced with that perennial issue of management not knowing to involve the HR team because all they're doing is applying business as usual. But the act of applying a policy or practice that is normal to do can itself be subject to attack under a discrimination arising claim. So that's practically difficult, but where you're able to intervene or assist management in these decision-making processes, the important thing for you to be doing will be thinking about what are the legitimate aims of the business that we're trying to achieve here in managing, let's say, the sickness absence issue. That's the most common example of a something arising that employees seek to rely on. And then the second part, and I think this is the part that's most often overlooked, is not just what are our legitimate aims, but are we acting in a proportionate way? And as I've said on the slide, proportionate, it means an appropriate means of achieving the legitimate aim, and also showing that it's reasonably necessary means of doing so. In other words, there aren't less impactful ways of achieving your legitimate aim that are less detrimental to the employee involved. And if you go through the thought process, and it can be a relatively short thought process, but if you go through the thought process when making key decisions or applying general practices to employees with underlying health conditions, of thinking, what are our legitimate aims? Are there less impactful ways of doing it? And then reasonably concluding that you're in a much better position to defend potential future discrimination arising from disability claims down the line. So that's my top tip number one, and now I'll hand over to Kathy to deal with the next one.
Right, good morning, everyone. So the next thing we're going to look at is the requirement to make reasonable adjustments. And specifically, we're going to look at whether sick pay should be extended for an individual who's off sick, long-term sick, with a disability-related absence. So just to go back over ground I'm sure you're all familiar with, but the duty to make reasonable adjustments is unique to disability as a protected characteristic. It doesn't apply to any of the other protected characteristics. And the obligation is effectively an obligation on an employer to treat the disabled person more favourably than others in order to reduce or to remove that individual's disadvantage. So it's one of the very few times that you can actually positively discriminate. So the duties set out in section 20 of the Equality Act, and that states that this arises where there is either a provision, criteria or practice, a PCP, or a physical feature of the employer's premises, or a failure to provide an auxiliary aid, which places the disabled employee at a substantial disadvantage. So the question that arises, and we get quite a lot of queries about this, is whether it is a reasonable adjustment to pay more sick pay to an individual who is absent with disability related reasons. So the good news for employers is that the general principle set out in the case on the slide of O'Hanlon is that it is rarely a reasonable adjustment to give higher sick pay to a disabled employee. And we'll come back to rarely in a moment. But what the Court of Appeal did when they looked at this case was they said, they looked at why there was a duty to make a reasonable adjustment. And they said that this is designed to enable disabled people to, and I quote, play a full part in the world of work and not to treat them as objects of charity. And extending sick pay is obviously not getting them back into the workplace, it's just alleviating the issues that they are suffering when they're away from the workplace. And they also commented that it could well be the case that offering more sick pay could even act as a disincentive to return to work. And I'm sure we've all had, if you've got company sick pay schemes, the situation where somebody who's been off on long-term sick miraculously recovers at the point that their full sick pay ends. So the Court of Appeal did agree with the tribunal in this case that the claimant had been disadvantaged as a disabled person because she had exhausted her sick pay for that disability related reason. But the employer, they found, had made all reasonable adjustments to assist the employee back into work, and paying her full pay to stay away from work was not a reasonable adjustment. Now, this did contrast with an earlier case, the Nottinghamshire County Council and Michael case, where the opposite finding was reached. And it was found in that case that it would have been a reasonable adjustment to extend sick pay. But in the Michael case, the employee was absent from work, at least in part because the employer had already failed to make other reasonable adjustments, which would have enabled her to return to her workplace earlier. So in that case, the court held that it would have been a reasonable adjustment to extend sick pay, partly in reliance on the fact that they had already failed to make the adjustments that would have got her back to work when she should have been able to return. Now, this case, and indeed the O'Hanlon case, was heard under the old Disability Discrimination Act, but it remains good law and is something that, you know, does come up quite frequently. Now, if you're looking at extension of sick pay, you will be looking at it under the Equality Act 2010. And as an employer, you will also need to consider if stopping a disabled employer's sick pay would be discrimination arising from a disability or indeed indirect discrimination. And Bob has just run through some of the issues that arise on arising from disability claims, and in particular, the need to objectively justify a decision a decision that where you know that there's discrimination, but that you're not going to act in a way that would alleviate that. So looking at sick pay, if it could be an act of indirect discrimination, which it could be, or discrimination arising from a disability, which could be justified by the employer and therefore found to be discriminatory, you need to conclude that it is a proportionate means of achieving a legitimate aim. And the failure to extend sick pay, commentary suggests that the effective control and management of company finances and the cost of the extended sick pay scheme, as indeed the impact on other members of the workforce, would be capable of falling into this protection and be a proportionate means of achieving a legitimate aim. So if you do have disabled employee who is away for longer than the sick pay extends, then you do need to consider if it should be extended in the particular circumstances of the case. So, for example, where there has been a delay on the employer, at least in part, has led to any delay. And quite often that can be a delay in relation to occupational health. But generally, you're not, as an employer, going to be under an obligation to do so.
This is one of those areas where we could spend the entire webinar talking about the intricate legal questions around long-term adverse effects. I put the standard definition of disability on the slide and underlined long-term. The point here is that in day-to-day practical situations, and I'm sure many of you will have found, you're often faced with employees who appear to have some kind of underlying health condition. It has not yet lasted a full 12 months to satisfy the long-term element of the statutory definition. And you are having to judge whether it meets the second half of the long-term definition that I put on the slide, i.e. that it's likely to last at least 12 months, or if shorter, the rest of the employee's life. Now, I've mentioned there the actually Supreme Court case of SCA Packaging and Boyle, and that was the case in which it was firmly established that the word likely in this context means something that could well happen. Now, where these matters are litigated, tribunals are required to assess from the position of the actual or constructive knowledge of the employer, based on what they knew or should have known at the time, whether it was likely, in the sense of could well happen, that the impairment would last for at least 12 months. It's worth mentioning that where a substantial adverse effect is deemed to exist because it is likely to recur, the tribunal will take into account the whole period in assessing whether it's long-term. It's also worth mentioning that the long-term requirement relates to the impairment rather than merely, relates to the effect of the impairment rather than merely the impairment itself. So it's not sufficient that a person has an impairment that is long-term. The impairment must have a substantial effect on day-to-day activities that is long-term. And I'll actually talk about that, as long as I can stay with you, a bit later when we look at the first of our case studies. If we move on to the next slide, please, Amy. I've just mentioned three things here. The importance of the employer's actual and constructive knowledge, the need for proper investigations, and the benefit of good medical advice. So, and as in any other claim, an employer can't be liable for discrimination unless it knew or should have known about the disability. And that comes from section 15.2, which states that there will be no discrimination arising from a disability if A shows that A did not know and could not reasonably have been expected to know that B has the disability. Now, there is obviously the positive obligation to investigate an employee's health conditions. The EHRC code actually says an employer must do all they can reasonably be expected to do to find out if a worker has a disability. But quite apart from that positive obligation in the Act, in practical terms, if you have doubts as to a situation as to whether an employee's condition is likely to last and the impact of it is likely to last for a full 12 months, you will be in a much better position to defend your actual knowledge and defend the point about it not being likely to be long-term if you are arguing based on reasonable attempts to investigate the impact of the health condition, the adverse impact on day-to-day activities, and having done so based on obtaining good medical evidence. It is so much more difficult to try to argue in retrospect, where in practical terms in an employment tribunal, the claimant's likely to have obtained their own or sort of joint expert medical evidence, so having psychiatrist reports for mental health issues, for instance, or other medical reports for physical impairments. And although the tribunal is required to assess the position from the point at which the alleged discrimination occurred, and in fact is not entitled to make a decision that simply because when you get to the point of the tribunal hearing, it has actually had that impact for at least 12 months, it needs to consider the likelihood, objectively looking at the relevant time. You're still going to be faced with expert medical evidence attempting to sway the tribunal to the claimant's point of view in many situations. So really the practical point here is that when you might have a reasonable argument that a condition is not likely to last 12 months, you're much better making that from the basis of actual well-informed knowledge than having to say, hypothetically, we couldn't reasonably have known based on what we did know, and assuming a reasonable investigation, that this condition would be likely, in the sense of could well, to have lasted for that period of time.
So the next top tip I'm going to look at is managing what is called associative disability issues. And if you look at Section 13 of the Equality Act, which is the direct discrimination definition, this provides that discrimination because of a disability is unlawful, but it doesn't necessarily need to be the individual's disability. So what we're looking at just in this top tip is, when can someone who is not themselves disabled, when are they able to bring a claim? And there are three basic circumstances in which this can happen. So it can include a situation when an employer treats an employee less favourably because of the disability of another person. And we'll have a quick look at a case in a moment, and that was somebody's child. The second situation is where somebody is discriminated against because they are perceived to have a disability, even if they don't in fact have one. And then last place that you can be discriminated against, being a disability discrimination claim, even though you don't yourself have a disability, is if somebody refuses to discriminate against a disabled person and therefore is subject to a detriment as a consequence. So we're just going to look briefly at the associative disability issue, because it's I think it's quite hard to get your head round. So this was established by the case of Coleman and Attridge law firms not doing what they're supposed to. So Mrs. Coleman was not herself disabled, but her son was disabled. He had a rare condition which affected his breathing, and he also had a hearing impairment. And her claim, which she sought to bring as a disability discrimination claim, was that she had been targeted by her employer because of her son's disability. And this manifested itself that she was given less flexibility in work, attending at work, flexible working requests than other colleagues who didn't have disabled children. And she was also targeted verbally in quite offensive language, and the suggestion being that she was using her son as an excuse not to attend work, or not to put as much into her job as her colleagues without children with a disability. And the tribunal, so what she wanted to do was to bring a claim saying that she had been subjected to unfair treatment because of a disability, and that was her son's disability. And the court concluded that she was able to do this in reliance on European law, and that she didn't have to have the disability, that the fact that the treatment related to the disability of a son meant that it was discrimination because of a disability. And she was allowed to proceed, and indeed succeeded with her claim. So that was associative disability in relation to direct discrimination under Section 13. But then there's been a more recent case of Follows against Nationwide Building Society, which looked at whether associative disability also applied to indirect discrimination. And this is particularly relevant as many organisations are trying to encourage staff to return to work after working from home, flexible working and hybrid arrangements. So the facts of this case were Nationwide had employed Miss Fellows as a manager as she worked from home. So she would she worked from home so she could care for her mother. And she'd done this for some considerable time, and she'd done it very successfully. And Nationwide had to reduce the number of managers at her level from 12 to 8. And as part of their reorganisation of their workforce, they required them to come into the office. Now, Miss Follows said, well, she couldn't do that because she'd been performing her role at home with no issue at all. She'd worked well, she'd supervised her staff well, which was a particular concern of Nationwide. However, Nationwide proceeded with reorganisation and they made her redundant on the basis that she wasn't able to come into the workplace. So the tribunal, she brought an associative disability claim based on the disability of her mother, who she cared for. And the tribunal held, firstly, that the case law meant that an employee could bring a claim for associated discrimination, even though it was an indirect discrimination claim. And they also found that it is self-evident that carers are not able to attend the office, so would be adversely impacted by the requirement that people attend the office, although, as Bob has said previously, it may be possible to objectively justify that requirement, but on this occasion, Nationwide failed to do so. Now, the Nationwide case is a first instant decision, so it's not binding, but we're already seeing a lot of queries about return to the office, where employees say they have caring responsibilities, which they might have started and picked up during lockdown or during home working arrangements. And they have been able to demonstrate already that they could and indeed have been work from home adequately. So when you're looking at asking people to return to the office, it's really important that where there are caring responsibilities, that you remain aware that there could be an associative disability claim. You may already be aware that where there are caring responsibilities, individuals, female employees may be able to bring a sex discrimination claim because judicial notice has been taken of the fact that women have more caring responsibilities. But there will now also be the obligation to look at and consider whether there is an associative disability claim, and whether a reasonable adjustment would be allowing individuals to work from home.
So Sulivan and Berry Street Capital. Mr. We picked this out because it's a Court of Appeal case from 2021, so it's quite recent, and we don't get a huge number of Court of Appeal cases. I think this is one of two of the five that we've picked out. And because of the actual facts of the case itself, and as I mentioned, this deals with the issue of likelihood of long-term impacts. So Mr. Sulivan was a senior sales executive. He was employed by the respondent employer since 2009, and his employers relatively early on identified concerns with his timekeeping and his attitude. I mean, that seems to have been an issue from the start of his employment, really. After a number of years, in May 2013, he unfortunately began experiencing paranoid delusions that he was being tracked and monitored by a Russian gang. And these delusions did affect his work, in particular his timekeeping and attendance. But Mr. Sulivan's condition improved. And so by September of 2013, he had reached a position where, while he still had the delusion and believed the gang was following him, he could manage his condition without letting it affect his work. However, despite the improvement in his condition, his employer continued to have concerns about his timekeeping and his attitude. And these concerns were raised regularly with him at reviews, going from July 2014 right through to September of 2017. And by that time, having not seen the improvement that they required, he was dismissed on the grounds of capability. And he brought a claim alleging his dismissal was discriminatory on the grounds of a disability. And the case was heard in the Employment Appeal Tribunal, heard in the Employment Tribunal, referred to the EAT, which upheld the original tribunal decision, and referred to the Court of Appeal, which upheld as well the Employment Tribunal, saying it was entitled to find that Mr. Sulivan was not disabled as a matter of law. And what the Court of Appeal said is that whilst his delusional beliefs persisted from 2013 to 2017, they had a substantial adverse effect on his ability to carry out normal day-to-day activities only between May and September of 2013, and then again from around April to June of 2017 until the claimant's dismissal. So on those specific facts, and I'd add a word of caution in relying on this in all situations, but on those specific facts, the claimant was unable to demonstrate a long-term impairment, so is not deemed to be disabled in law. And the key distinction here is between long-term impairment and long-term adverse effect, which you couldn't show. So that's the Sulivan case, and we can move on to the next slide. And Kathy, please, Amy.
So the next case is the case of Aleem against EACT Academy Trust. And in this case, it's the Employment Appeal Tribunal decision in which they looked at whether it was a reasonable adjustment to continue to pay an employee at a higher pay rate when they had taken a lower paid job. So Ms. Aleem was employed as a science teacher at EACT Academy Trust, which is a large multi-academy trust. And following a period of sickness on account of her mental ill health, she became unable to continue to teach. So there were discussions about alternative work patterns and roles. And Miss Aleem asked to work as a teacher for 2.5 days a week. But EACT rejected that request as it couldn't be confident that they could get a supply teacher to cover for the other 2.5 days. So Miss Aleem raised a grievance while she was still off sick. But during an absence review meeting, she did accept the option, which had been discussed with her, of returning to work 3 days a week as a cover supervisor. Now, the role of cover supervisor attracted a lower rate of pay than her teacher's pay rate. However, while she was on her initial probation period in the cover role, she was continued to be paid the higher pay rate. And they also continued to pay her the higher pay rate while they heard her grievance against the unfair treatment that she said that she had been subjected to, and also her grievance appeal. Occupational health then determined that she was going to be long-term unfit to return to the teaching role, but that she was fit to carry on with the supervisor's role, the cover supervisor's role. And Miss Aleem accepted this position and the reduced pay rate as a permanent appointment. However, she then changed her mind and she brought a disability discrimination claim on the basis that it would have been a reasonable adjustment to pay protect her salary at her teacher's pay. Now, we looked earlier at whether there was an obligation to extend sick pay, and as stated by the Court of Appeal in the O'Hanlon case, all relevant factors must be taken into account. But in this case, the EAT concluded that it would not have been a reasonable adjustment to pay protect permanently while she undertook the lower grade role. They pointed out that in this case, there was a clear point at which a line could be drawn, that she had been told that the pay would decrease on completion of the probation period and at the end of the grievance process, and that she had also, and that this had been clearly communicated to her, so she was aware. And they also were mindful of the fact that the employer was a publicly funded body and was facing severe financial pressure at the time. So again, I think a helpful decision for employers in relation to pay protection, which is something, again, which is often raised by employees. And it's also important if you're looking at a phased return to work, where part of the phased return may well be reduced hour working, but on an interim basis with a view to getting people back to work full time. And it's very important to be clear that pay is only protected for the period of the phased return when that's fixed up to the point when there's a return to full hours. If at the end of that period the employee is disabled and needs to have a reasonable adjustment to hours or to role, then you need to consider whether pay protection would be a reasonable adjustment. And if it is not, then go through the reasoning, as Bob decided earlier, to record why you think it's not a reasonable adjustment, or indeed whether it could be objectively justified if it's arising from discrimination. So as for sick pay, in many situations, it will not be a reasonable adjustment to offer pay protection indefinitely. Thank you, Bob.
Thanks, Kathy. Amy, can we have the next slide, please? Thank you. So the next case is Ishola and Transport for London. So this is a case, as it says on the slide, where Mr. Ishola, who was employed by Transport for London, suffered from depression and migraines, which did amount to a disability. I've slightly oversimplified the time scale there in the slide. What actually happened was he brought a grievance against a colleague, and the outcome of the grievance went against him. Then he was signed off sick and started to raise wide-ranging grievances about the outcome of his initial grievance and various other things that he was unhappy with. And Transport for London eventually went through a medical capacity procedure with him and dismissed him on the grounds of incapacity without resolving his grievances. And he brought various claims, including a failure to make reasonable adjustments. And his argument was that dismissing him for incapacity while a grievance was outstanding amounted to a PCP of requiring him to return to work without a proper investigation into his complaint. And this is another case that went all the way to the Court of Appeal. And it's quite a nuanced judgment, and one, again, that requires handling with care when you apply it in practice. But the Court of Appeal held that Transport for London's failure to investigate the grievances in this situation was not a PCP. On these facts, there was nothing to indicate that the decision would be applied again in the future, or that this was the way that things were generally done at TfL. And so the evidence in this case showed that the particular timing and circumstances of the grievance in question explained why the grievances were not investigated before the dismissal. So this was a one-off decision, and therefore outside of the definition of PCP. It was not a provision, criterion, or practice. Now, unfair treatment that includes a one-off decision or act can be a PCP, and the Court of Appeal confirmed that, but it will not do so unless there is some form of continuum in the sense of how things generally are or will be done by the employer. There must be a state of affairs indicating how similar cases are generally treated, or how they will be treated in the future, in order for that kind of one-off decision to be capable of amounting to a PCP. So it is a case that is helpful to employers and can be directly applicable to situations where a decision like a capability or disciplinary outcome it needs to be determined. But you do have to be careful to establish that what you're doing is making an isolated decision based on very specific facts, rather than simply applying the same approach that you always apply in such situations. Nevertheless, whilst relatively narrow, it is quite helpful to employers. Thank you, Kathy. Amy, can we move to the next slide for Kathy's next case report?
So the case of Donnachie and Telent. So in this case, the tribunal considered if menopause symptoms were substantial enough to amount to a disability. So Miss Donnachie had some symptoms of menopause. She had hot flushes 7 to 8 times a day. She had palpitations, feelings of anxiety, and these symptoms increased if she was under stress or pressure. She then also started having night sweats, which interrupted her sleep, and this cumulatively resulted in her feeling fatigue, suffering from anxiety, and memory and concentration difficulties. She did take HRT, which improved her symptoms, but they did persist, and you'll be aware, obviously, when you're looking at a disability, that when you're looking at the effect on day-to-day activities of a disability, that treatment is disregarded. So the tribunal had to consider whether these menopausal symptoms were sufficiently serious to constitute a disability. And the employer, Telent Technology Services, said they were not. They said, firstly, that these were typical symptoms. And menopause wasn't itself a disability, it was just a thing that happened. And secondly, that the impact of these symptoms was not substantial, which is one of the tests for making out a disability. And the tribunal looked at it and they made a number of findings. Firstly, they found that there was no reason in principle why typical menopausal symptoms could not amount to a disability. And on the facts, they also concluded that the menopausal symptoms in this case were more than minor and trivial. So therefore, the definition of disability was met, and Ms. Donnachie was able to proceed with her claim as a disabled person. Now, this is a first instance decision, but this is one of a series of cases where tribunals and the EAT have decided that menopausal symptoms do amount to a disability where the impact on day-to-day activities is substantial. Obviously, this will depend on the facts of each case, because for some women it may not have such a significant impact. I think this is important because menopause is obviously much in the news at the moment. And in other cases, although the menopause was found to constitute a disability, the claims did not succeed on the basis that the employer did not have actual or constructive knowledge of the disability. So that's the point that Bob was just making, that you need to have actual or constructive knowledges in order for you to, as an employer, have an obligation to treat somebody as a disabled person. But as employers introduce menopause policies in the workplace, and the taboo on referring to menopause is sort of broken, and people become more aware generally of the issues faced by menopausal women, it's no doubt going to be harder for employers to say with any degree of credibility that they were not aware of the disability suffered by a menopausal woman. So I suppose as employers, it would be better to take a positive and proactive approach to supporting women as they go through the menopause, for example, by varying hours, rather than risk facing a disability claim. Thank you, Amy.
Thanks, Amy. And then the final case we're going to talk about is Primaz and Coal Room Restaurants Limited. This is one that we selected because it's partially because it's just such an unusual case on its facts, and therefore just a bit interesting from an employment and HR practice point of view. So as it says on the slide, Ms. Primaz suffered from epilepsy and I think it's vitiligo, I'm not quite sure how to pronounce it, but the skin condition. She also had suffered from cancer, but the employment tribunal found suffer from cancer during the times relevant to what she claimed to be her unfair treatment. It did decide that her epilepsy and skin condition, I'm going to say, amounted to disabilities. But the EAT said that the tribunal had made an error in coming to that decision. The reason for that was the claimant had various coping mechanisms, avoiding things like caffeine and alcohol and any cosmetics, any kind of sun cream, and any kind of prescribed medicines to help her manage the effects of her epilepsy, for instance, seizure medicines, which on the evidence before the tribunal, it was determined that she was strongly recommended by her doctors to take, but chose not to, wrongly, it appears, believing that they would trigger her conditions. It appears that Ms. Primaz did a lot of her own research on the internet and chose to apply alternative interpretations of medical care instead of the advice of her doctors. And these avoidance mechanisms themselves added restrictions to what she could do, which led her into conflict with her employers, which led to the issues that eventually became her tribunal claims. And the Employment Appeal Tribunal upholding the respondent's appeal against the decision that her epilepsy and skin condition amounted to disabilities, said that the tribunal should have disregarded the claimant's coping mechanisms, even though her belief that they were necessary was strongly held. It should have considered the impact of the actual conditions had on her day-to-day activities, leaving aside the impact of her avoidance behaviors. Now, if what she was doing was the result of following medical advice, the outcome might have been different. It also might have been different if the claimant who represented herself in the employment tribunal had actually sought to argue that she had a disability as a result of a mental impairment, but she didn't plead her case in that way. She was only arguing physical impairments. So the EAT said that you've not properly considered the impact of the potential impact of the underlying condition because you've been lumping it together with the impact of non-medically recommended avoidance mechanisms, which are the result of decisions by the claimant. And so it remitted the case back to a fresh tribunal to determine those issues. So this is, I don't think, necessarily a case to draw too much a helpful HR practice from. We picked it to round things off just because it's quite an unusual situation, and we thought interesting to flag to you. So that concludes our run through of our top tips and our case law updates. I see we've got a couple of questions in the Q&A, so we can turn to those now if you like.
Brilliant. Yes, we've got a couple of questions. So the first one, to what extent could occupational health advice, which appears to suggest doing nothing for now, be overlooked, and what are the risks of doing so? We have an employee on long-term sickness absence who has repeatedly failed to provide updated fit notes in a timely manner or maintain regular contact with their manager despite being requested to do so. The OH advice received appears to validate their condition as justification for them not maintaining appropriate contact or following such instructions, but cannot predict a time frame for improvement nor recommend any formal HR processes be followed until they do improve.
Well, I suppose the first thing to say is that it probably won't be any surprise to any of you that I say it's always quite the risk to depart from the recommendations of your OH advice. And the first thing you're going to need to be able to explain is why it is considered necessary to do so. What is it that's driving the need to push forward with taking some kind of action against the employee when your OH, my interpretation being that your OH is saying they have an underlying health condition. One of the consequences of the underlying health condition is an inability to provide timely fit notes and updates on their health. And you should take that into account in how you deal with the employee. It wouldn't be a difficult case for a claimant to make out, if that condition is a disability, that the failure to engage with fit notes is something that arises out of the disability, and that if you ignore OH advice and proceed with a capability or disciplinary process, that is less favorable treatment in relation to that something arising. So that puts you on the objective justification scale to defend the claim. What we don't know in the question is why you feel the need to move ahead despite the OH advice, and you know, what factors need to be weighed up in considering proportionality. I won't say that it's impossible to do it, because depending on the specific situations, there may be a way to objectively justify an action, but you're going to have a specific and carefully weighed reason in order to be able to proceed, taking into account all of the relevant factors. So it is risky, and in many cases would lead you into legal difficulties. But depending on the exact circumstances, I hope that's not too wishy-washy a response. There may be a way to depart. It's never a straightforward thing to do, to depart from the medical advice you're receiving, and you've got to have good reasons to do so.
And the only thing I would add is that obviously your own procedures, you might need to make a reasonable adjustment to them to reflect a disability. And it sounds like this might be a mental health issue. So very often with mental health issues, a reasonable adjustment process is not to follow them to the letter. The only other thing I would say, however, is if fit notes aren't arising, obviously you won't be able to pay sick pay necessarily. So you do need to make it clear to the employee that they do need to produce a fit note or a sick note before you're able to process their sick pay. Okay.
Okay, great. Another question we've got in: if an employee has a disability which automatically falls with the realms of the Equality Act, do you always have to make adjustments? So, for example, home working, if the job role does not allow the flexibility to do so in order to maintain consistency across a team, what are the risks if adjustments are not made?
Well, the starting point from that is you must consider making reasonable adjustments in all circumstances where there's a disability, and home working for some disabilities is likely to be one of those. It then comes down to what is a reasonable adjustment, and that's, you're then balancing how effective it is in getting the employee engaged in work in an appropriate way compared with any detrimental impact on service delivery, colleagues, etc. However, consistency in itself is unlikely to be a reason for refusing a request for a reasonable adjustment, because almost by definition you can't have consistency where somebody's disabled, because the point of a reasonable adjustment is to put them on the same footing as somebody who doesn't suffer from that disability, to enable them to participate in the workplace. And the risks if you don't make reasonable adjustments are a disability discrimination claim. So yeah, substantial compensation potentially. Next one, Amy.
Great. We have an employee who has been absent from work for 3 months. They have confirmed in writing they do not have a disability, but do we accept that? Or do you think we should get OH to confirm this, as the employee is off work citing work-related stress? I'm thinking ahead regarding a possible personal injury claim, so want to be proactive and have as much info as possible.
Yeah, I think that's a sensible way to approach it. The tribunals have made clear that you can't simply take an employee at their word. And in fact, there's a couple of paragraphs in the EHRC code that talks about situations where the employees may not regard themselves as suffering from a disability, but nevertheless it being important to investigate underlying conditions and make an objective assessment yourself. So yes, I don't think you should simply accept an employee saying that they do not believe themselves to be disabled. It would be sensible to obtain your own advice, absolutely.
Great. We have someone who has recently suffered a minor heart attack, who now has a stent, and they are now on long-term medication to help manage this. Am I assuming that they are considered disabled?
And not necessarily, because there needs to be an impact on their ability to undertake day-to-day activities. So, some people can have a minor heart attack and actually recover pretty much completely. So I think that when you're looking at adjustments, you might want to work on the basis that they may well be, but they don't necessarily hit the bar. And I suppose it only becomes an issue if you need to make adjustments to working patterns or the particular requirements. If they return to work as normal, obviously you'll keep an eye on their health, but it might not become an issue. So I'm not quite sure of the context of that question, but so probably, but not necessarily.
You can have an odd situation where they might be regarded as suffering from a disability because of paragraph 5 of Schedule 1 of the Equality Act, which says that an impairment will be treated as having a substantial adverse effect if measures are being taken to treat it or correct it, and but for the measures, the impairment would have the adverse effect. So, and that expressly includes medical treatment. So you can have a situation where, because of the medical treatment, there's no adverse effect, but nevertheless they'd be regarded as disabled. But because there's no adverse effect, your duty to consider reasonable adjustments, for instance, isn't triggered. So the answer might be yes, but nothing much changes in practice.
Okay, great. We've got another question in. We have a teacher who had cancer 3 years ago and still has regular illness. We would like to take out a capability issue, as this term they have only been in 30% of the time. It is difficult to make reasonable adjustment as a teacher needs to teach children. Should we refer to occupational health first?
Yes.
Yeah. Yeah, there's not much more to say than that. You need good information about what's causing the regular illness, its connection to underlying conditions, the impact on ability to carry out day-to-day activities, all of which will be relevant to your risk assessment. So it's a very good idea to do so.
And before we finish, there's just one I noticed in the chat. So it's if a new employee declares a mental health issue on their medical form, and when we talk to them, they say it is controlled by medication, can that be used as giving the employer knowledge of a disability later down the line? And the answer to that is again, yes. You know that they've got a mental health issue, and the fact that you've now got actual knowledge, even if it's controlled, does mean that you're aware of that disability and would need to take it into account in future dealings with that employee. Okay.
Okay, brilliant. I've just seen there's one more that's just come through to the Q&A box, and if we've got time to quickly go through that one.
Just a thank you, isn't it?
It just says, probably not specific enough, but what steps can be taken outside of occupational health advice can an employer take to investigate an employee's disability, especially if they have refused consent and also have not disclosed this in one-to-ones or as part of discussions?
Yes. Well, I think it is difficult in those circumstances to obtain good information about the nature of the employee's health conditions and their impact. But your actual knowledge will therefore be relatively limited, and it puts you in a relatively good situation to argue that your constructive knowledge, i.e. what you reasonably could have known, is also limited because the employee is taking steps to conceal from you the impact. And there are cases on employees who conceal the impact of their condition, and that limiting the risk to you because you couldn't reasonably have known in those circumstances. And it will depend on your, as you say, your specific situation, but in many situations, it puts you as the employer in a better situation in terms of protection from disability discrimination risk.